Culture Studies, Jawaharlal Nehru University, and Mrs. Uma Ramanathan, advocate, mediator and mediator trainer, and special guest Ms. Anu Monga, partner, Anant Law. We also have with us Professor Dr. Anjuvali Tiku, Professor in charge, Law Center 1, Faculty of Law, University of Delhi, and Professor Dr. Rajni Abbi, Law Center 2, Faculty of Law, University of Delhi. We shall now begin with our third session for the day, Indianization and Legal Education Reforms. Let me now invite Professor Dr. Anjuvali Tiku, Professor in charge, Law Center 1, to give the welcome address and flag off the day's program.
Yeah, before Anju starts, Justice Menon sir, namaskar.
Yes, namaskar Usha ji, namaskar. How are you?
I'm fine, sir. I'm sorry, मैं उस दिन की मीटिंग नहीं अटेंड कर पाई. Actually, 2 दिन पहले ही था, तो इस प्रोग्राम में भी
नहीं, कोई बात नहीं, कोई बात नहीं.
Missing, I mean, working under you on that particular day.
We'll catch up some on the next meeting. Don't worry.
Justice Bhandari sir, namaskar sir, and thanks for coming here to enlighten the our students. वो है क्या? This is
join नहीं किए लगता है.
He hasn't joined.
He has not. He'll be joining in some time.
Professor Paranjpa has joined. Paranjpa ji, good afternoon.
Paranjpa is there. Usha Ramanathan ji, welcome again. And I think Anu has also joined.
Yes, ma'am.
Anu, yeah.
Yes,
well, good to see you. Yeah.
Likewise.
Yes, Professor Anju, now you may, take the formal whatever is there. I'm sorry, I have interrupted. Ashi has not recognized, counted me, you know.
It doesn't matter. It doesn't matter. Students learn. Students learn with the passage of time. That's how they experience.
You may go
anyway,
ahead.
नमस्कार, आप सभी का अभिनंदन है, स्वागत है, and I invite you all for this session. As we all understand that we are celebrating the centenary year, having the centenary year celebrations of University of Delhi, and just a small contribution from Faculty of Law in the form of this conclave, but then it is a significant one in the sense that we have chosen the topic of Indianization of a legal system and education. And the fact remains that we have been for quite some time in the recent past talking about looking inwards, be that in the physical sense or in the spiritual sense. So if we relate the two, we need to understand that what is the advantage of looking inwards. And when we talk about the local efforts and local inputs in living our own lives, I believe the specialists in this panel, 5 of them having their illustrious accomplishment in their unique manner in their respective fields, are the best persons who can share with us their life experiences and their knowledge. And since we have the audience in the form of not only the students, but also the paralegal volunteers and also people, advocates who are with the different state legal service authorities, this is the right forum wherein interacting with different stakeholders within the legal system, we can perhaps think of bringing about some change in our attitude and the framework of the law. So, and I was just wondering at this point of time that 5 of you with such illustrious careers, and we have got just 1 hour. I'm really sorry for that, but I'll just pin 1 or 2 achievements or your placing and your stature in your own fields, and then invite you to please address us and enlighten us about your thought processes about what do you think about Indianization and legal education reforms, which is the focus of this very particular session. I believe we have all seen that we had 2 previous sessions in the morning. The very first one was talking about access to justice, and access to justice with reference to vulnerable groups. And we were also talking about somewhere the linguistic barriers. Then we had the second session which talked about the use of how to use technology in Indianization of legal system. And I am happy to inform you that we did have, again, judges, we did have advocates, we did have social thinkers who participated throughout these two sessions. And now we are into the third session, wherein we are carrying the thought processes from the first two and over to this session. We are now going to focus on what kind of reforms we can bring in. So to begin with, we have with us Honorable Mr. Justice Rajendra Menon. I don't think we need to have much of we need to talk about the fact that he has in fact interned and was associated with Justice Sadashivam at some point of time in his career. He has practiced as senior advocate uh, and with Justice Sadashivam Nair, and until his elevation to the bench, he was the standing counsel for central government from 1991. So being an advocate over to the bench, and certainly as person who has got vast experience moving across to different benches, different high courts, and then ultimately being appointed as the chairperson of the Armed Forces Tribunal on 6th November 2019 by the Appointments Committee of the Cabinet. Sir, we welcome you to this session and we look forward to hearing from you your words of
Thank you very much.
interaction, inter relationship between the current legal system, which is so-called the colonial legal system, and when we talk about the Indian legal system and how do we bring about a reform within that. For the timings, thank you very much, sir, for accepting our invitation and gracing this occasion. I'll take the liberty of the chair to not welcome Justice Munishwar Bhandari at this point of time because he has not joined us. The moment he joins, we will certainly welcome him at that point of time.
Proceed.
Thank you, sir. Thank you, sir. Then we have with us Madam Uma Ramanathan. Again, I was just going through your profile, madam. Such a wonderful profile that you have graduated from language, English over to law, and then has a training in mediation. Also, the fact that you have organized several programs and organized programs pertaining to mediation and reconciliation project committee by the Supreme Court of India. You are a trained mediator and you are the one who has drafted the mediation training manual for not only the mediators, but also helping out the judges somewhere in understanding the process of mediation. And for sure, you have presented several papers in various conferences, sharing your thought processes about how do we need to move forward instead of the formal legal system into the mediation, which would be more casual, more informal, and perhaps would bring in finality. Thank you very much for accepting again our invitation. And we look forward to certainly hearing from you, and more so because you happen to have some experience from criminological perspective also, and I happen to have an interest in that. So I look keenly forward to hearing your lecture, madam. Over to sir. We also have with us the guest of honor, Professor Makarand R. Paranjpe. Sir, I've had the opportunity of hearing you on various platforms, and I'm a great fan of yours, the way you convey your thought process and very softly and spokenly, but yes, very firmly, you give the in-depth understanding of the intricacies of language, culture, and law. Again, welcome, sir, and we look forward to hearing you. And I really am looking forward to, again, some meaningful, as usual, discourse from you, wherein we talk about the Indianization of legal system and more with reference to reforms. And that brings me to the last panelist for the time being, Ms. Anu Monga. And I was happy to see that she happens to be an alumnus of Faculty of Law. So we have carried that legacy that in each session we happen to have our own alumnus. Anu, I am really happy to see that you have reached a pedestal in your own life, in your own professional career, wherein you are invited as a special guest in a program by the Faculty of Law, that too when we are organizing our centenary celebrations. Welcome, Anu, back to your alma mater, and we look forward to interacting and greater collaboration with you. Thank you very much. And with that, I look forward to listening to the discourses, your thought processes. Thank you very much once again from Faculty of Law and on behalf of the University of Delhi, and for sure, me in an individual capacity. I welcome you all. Suswagatam. Over to you, Ash.
Thank you very much, ma'am, for this introduction. I would like to now invite our special guest, Ms. Anu Monga, to kindly address the participants.
Thank you, Ashi. Thank you for this. I'd like to take the permission of the chair, Honorable Mr. Justice Rajendra Menon.
Yes, Anuji, please proceed. Please proceed.
Obliged. I'd like to thank the Faculty of Law, University of Delhi, for inviting me to this prestigious event where the University of Delhi itself is celebrating its centenary year, and Faculty of Law being, according to me, the heart of how the social economic changes are going to come about, has taken it upon themselves to put on this conclave. My heartiest congratulations, and also thank you for having me on board. And like Professor Anjuvali Tiku just mentioned, that I am an alumni from Campus Law Center myself, and it feels like not too far back in time. I was taught by Professor Usha Tandon, and I hope ma'am's not going to say that I missed a lot of classes. But yes, I was taught by Professor Usha Tandon, and I have very, very good memories of how passionate ma'am used to teach the classes. And I think when I think about this topic, Indianization and legal education reforms, the one thing that comes to my mind is really somewhere I feel that the passion with respect to teaching and receiving as students has gone missing. And that passion used to be part of the culture of Indian learning overall, according to me. When I read articles and I read different things, it wasn't the ambionization, so to speak, the making everything into a management course, which is what I feel the legal education has also turned out to be. Instead of I won't say that necessarily the 5-year legal courses are doing that, but it's how you want to make everything into a machinery and want it to run a certain way. There is less internalization. There is less thinking of the core ideas of legal profession, which is ethics, conflict of interest. Those things have gone missing somehow, not only because of legal education, but when there used to be a time period that there was an apprenticeship period or 1 year. So when you were working with senior advocates, you would understand the meaning of and the value of ethics, and therefore would understand the value of having a certain prestige, because law as a profession demands nobility, demands respect, not only from the clients that you represent, but the overall bar, the judges, the peers, everyone. And if you're not respected, then somewhere down the line, you will not be able to bring in the best results overall. So to me, the lack of overall internalization of thinking things internally and thinking about the law internally is something that has led to the ambionization of the legal education per se. Just this, I don't think I really have any other comments per se apart from this. All I'd say is that I've had a very, very short legal career compared to our chair and our co-chair and everyone else here. And I'd like to listen to everyone else's views on this issue. as to how the education itself legal education itself can undergo changes to bring about more. All I would want to say is that before this topic was mentioned to me, I did happen to read about a lot of issues in terms of indigenization of the legal education system and the legal reforms overall, not only in India, but also in other, so to speak, colonial countries like South Africa, Singapore, Australia. This is, it's not just a voice that is coming out of India, but also other countries where they feel that their indigenous legal system and education system somewhere got left behind, and that's why it's not able to, today's legal processes are not able to solve the problems of the present India, present, the situations, socioeconomic, cultural problems that exist in a particular country. Thank you so much.
Thank
Thank
you,
you,
ma'am.
Anu.
Your
Very good.
words were truly enriching and inspiring.
Thank you.
Now I would like to now invite
Yes,
our
Miss
guest
Menon
of
is saying
honor.
something, I think.
No,
Sir,
no,
you were
it's
saying
okay.
something.
Continue.
Now I would like to invite our guest of honor, Mrs. Uma Ramanathan, to address the participants.
Thank you. Namaskar to everyone here. Honorable Justice Rajendra Menon and all the other panelists here and all those who are listening. I think we are blessed to have this topic today, especially in the light of this centenary celebrations being going on. To mark a particular situation, we always like to look back and assess, and we also like to evaluate what is happening in our lives, and we like to fix goals. And I think this is one point for the Delhi University. This conclave has set the tone for all of us to objectively reassess what is happening with us as lawyers, as part of the judicial system. As it was earlier said, this 7 minutes is very little for what we have to discuss on this topic. But I'd like to just point out a few points. Maybe we could have a longer discussion later on, or something could be arranged later. When I was thinking about education per se, not just legal education, what is education? Education is not just giving information. Information today is available anywhere at the touch of a button. Anybody can handle any information. But what sense does it make to that person? And I remember long back reading W.B. Yeats, who said that education is not just filling of a pail. We just don't add things into it and fill up that pail, but it is lighting of a fire. So have we done that? Are we lighting a fire? Are we making people passionate about what they are doing, or concerned about what they are doing? I have to honestly admit that I can't say that we are lighting a fire, because we are just sort of putting them in a groove, getting them to be either corporate lawyers or somebody who can make money, or somebody who can get along with their lives more than anything else. They have a student loan, they have to repay it, they have to have a status in society, so they have to do this. So that's all. That is the goal. But that is not the goal of legal education. And when we look back, we find that in our system, what was Vidya? Vidya is, generally you can say education, but Vidya is more than that. It is experience, it is understanding, it is wisdom. And what they say is that knowledge itself is divided into Paravidya and Aparavidya. Now, Paravidya is wisdom and Aparavidya is information. So as I said, information is available everywhere. But how do we understand? And as Anu said, how do we introspect? How do we reflect on it? How do we make use of it? Now, we talked about access of justice. We talked about using technology. Yes, all that is very, very relevant. But are we looking at the social cultural milieu? Are we understanding what is it that the people at the grassroots level need? Or what is it that young lawyers find in this profession to keep them engaged in that? So what is this core of this engagement? So there, that fire is missing, because there is no clarity, and what is there is just information that can be accessed on the net, on Google. Everyone says, oh yeah, I can get it on Google. So we don't remember even, or we cut and paste. I remember one of our judges telling me that when she was signing the order, she found that it was a cut and paste, and a judge who had earlier retired, his name and some other date was there. And that was after the revision of the order. So she said, it's so difficult, Uma, today, this cut and paste, and we have to look at every full stop and comma. So that is not education. Education is much more. So if we, I won't go into what is profession and education, but I mean, it is legal education is something which makes you ready for a profession. So then what do we need in that? There must be some sort of structuralization. And for that, we have to understand the socio-cultural milieu, because law is reflection of the society. And it's not just norms. That is why India is in a peculiar state. India, the cultural ethos understands what is dharma. Dharma is much more than norms. Dharma is much more than the statute. Dharma is something that you feel that what is right you have to do, or it is mostly situational. And it is so surprising that I think it is only in the Indian context we look as truth as not just absolute. It is, of course, it is called a satyam, where it is absolute, but there is something called rita also, which is contextual. So depending on the context only, Yajnavalkya Smriti talks about punishment for each caste, depending on the situation, how pleadings or how evidence has to be considered. We have forgotten all that. Tarka Shastra teaches you how to interpret. We have forgotten all that. All that is more relevant, not just for legal practice, but is also necessary for our day-to-day life. So in this legal structuralization, what we have to understand is the socio-cultural milieu for one. What we have to understand is that we need to prepare people to be conscientious. Are we doing that? There is no integrity. Last week, somebody came to me from the Madurai bench saying that there was a CRP, and unfortunately, the lawyer has said the plaint was, when it was filed, had been rejected, and the lawyer had said that the judge order will not be given because it has to be got only by order from the High Court. And I said, nothing can happen like that. You just find out what is happening, or get me the typeset at least. And then I find he has changed the dates in the plaint. He has altered everything in a specific performance suit without the knowledge of the clients. And that is why it was dismissed. The plaint was returned. Now, this is the kind of people that we have. So is there a conscience? Are we conscientious about what we are doing? Are we culturally relevant today? If we think about that, then we understand that to be a lawyer, or to be a person who says you can help another person advocate his cause, you need to have an identity. And how do you build an identity? Unless you respect yourself, you won't be able to build an identity. And once you have that identity will depend on the kind of understanding of the law or the practice of law that you do. And that creates a status. All this is managed only when we feel that we are responsible. Most of the time we feel that we are not responsible, or we are just there. We are not even answerable to our clients. We feel, okay, he's given the money, ask him to come back after 6 months. No, that's not the way. I remember when I was talking to Justice Venkatachalaya once, he said, most of us don't understand the pain of the litigants. This pain of the litigants can be understood only if we understand ourselves, as Anu was saying. And for that, there is a moral conscientiousness that we have to have. It is not just judgment. It is not just sensitivity. It is more of bridging the knowing and doing gap. That moral reasonableness comes out of what Aristotle calls as the practical wisdom, phronesis. He says, you must have the will, you must have the desire to do what is right. What is practical intelligence is you will know what is right. That is, you can learn from the textbooks. You have knowledge everywhere. So you have a cognition, and then what do I say? You will know that this is what has to be done in a particular situation. But how to do it, or whether there's a willingness to do it, will depend on practical wisdom. That wisdom comes only with experience. And as Anu was saying, we need to have something like the chartered accountants who go into apprenticeship. Although the 5-year course does give a better chance to look at things practically than the 3-year course, it is very, very important for them to have a hands-on experience to understand what is happening. I remember when I first joined my senior's office, it was a clerk who taught me most of the things. He knew much more than what I knew, because he had been in the office for 30 years. And I was wondering, where is this man taking me in the High Court? But he used to tell me, look at this fellow, sit there, he numbers it. And then I understood what was the real reasoning. So any legal education reform today has to not only think of what is domestic, but has to also look at the demands of the global thing. But we must also understand what is this justice delivery system. You must understand that there has to be a holistic training. So it can't be just, we can't say, okay, we'll go back to the old times. Chanakya had a very good Arthashastra. We can just follow that. It can't be done. What we have to understand is, what is my Swadharma? What should I do? What is this that is expected of me? So broadly, I would say the objectives have to be, one is social. We have to understand the environment, the ethos, the values, and what are the problems that both the litigants and the justice dispensation system is facing. Then efficacy. What is the potential here? It's not just book knowledge. We need skills. Even in drafting, you need very good skills. And today it's cut and paste, unfortunately. So we have to have skills, and we have to constantly update the skills. So we need to have a social dimension. We need to have an efficacy dimension. We need to have opportunity. Without an opportunity, how are people going to practice those skills? And because today, in the changing world, we have different sets of problems, different approaches. We have to be aware of that to deal with all those issues. And more than anything else, I think we need to develop a sense of commitment. And that also has to be taught today, unfortunately. And without that sense of commitment, nothing can be done. So I will just like to say that although we can't talk a lot today because of time constraints, what was succinctly said in the way the Vedanta taught was Shravana, Manana, and Nididhyasana. Whole thing is about listening. First, we have to learn to listen. As a lawyer, we have to learn to listen. As a judge, we have to learn to listen to our clients, what the opposite side is saying, what the judge is saying, everything else. And then we have to reflect on it. And unless we reflect, we won't be able to come up with what is expected of the situation. And only if we are listening properly and there is a reflection, then there will be internalization of the whole thing. So going back to what our original thoughts were, it concentrated on the self, development of the self, consciousness of the self. And that is what today we are learning from psychology as Albert Bandura's the self-efficacy or self-determination, which we teach in mediation. But I think the most important factors that we have to keep in mind today in legal education, especially, is teach the students to respect themselves and to respect others. Teach the students that they are responsible. They have to have a sense of responsibility, not only to the clients, but to the whole system. Because today, all the challenges that the justice dispensation system is facing is because of how we are acting. And unless we understand that we are responsible for this, there is a lot of literature today, and I have just probed the tip of the iceberg, because I came into contact with what is Vedanta and all that, and especially the Kashmir Shaivism Vak and all that. And I've been trying to infuse it into our training. But unfortunately, I'm not well versed in all that. And I would really like scholars who know all that. And for universities like the Delhi University to come forward and interact, because the Maharashtra National Law School had Justice Krishna coming to talk about Tarka Shastra for their postgraduate program. And I listened to those lectures. It was wonderful. And I think somewhere getting different perspectives, it is not just Indianization. As Anu was saying about indigenous cultures and whatever was there, because that is part of our ethos. We have to recognize that. But more than that, I think understanding the values, understanding what is the potential is there, and whatever was spoken about all those years helps us to understand and respect each other and recognize, to take ownership over whatever is happening today. And I think today, if we leave it, we are also responsible for the downslide of whatever is happening, and we have to do something. So thank you for the opportunity.
Thank you so much, ma'am. Your words were truly inspiring and enlightening. Now, I would like to invite our guest of honor, Professor Makarand R. Paranjape, to address the participants.
Unmute your mic, Mr. Paranjape. Unmute your mic.
Okay, thank you.
Yeah.
So thank you so much, Honorable Justice Rajendra Menonji, the chair, and distinguished colleagues, and also members of this panel. As time is limited, I'll come straight to the 2 or 3 points I want to make. The first point is that it's really very important that Delhi University, which is, of course, celebrating its centenary year, and I'm also an alum of Delhi University in the wider sense. I was a student of St. Stephen's College and I read English there. But the law faculty of Delhi University, which is one of the most distinguished and oldest, I should say, also eldest of our legal faculties, has taken this initiative to proceed to create a kind of awareness all over India, in the bench, in law schools, among the students, as well as the legal fraternity, about the challenge in realigning our entire legal and judicial system towards the Indian ethos. And I think I've been in 2 or 3 of these sessions. I've even written a paper in a book that is supposed to come out. So I think that the first point I want to make is that this is a very, I think somebody's mic is on and they need to switch it off. So that,
Umaji's.
yeah, if you can, if the coordinator of the session can switch off that mic.
Madam Uma, you can unmute. Yeah, she's unmuted now. Proceed.
Okay, terrific. So let me come back to the point. I'm saying that this is a really important initiative. I would call it a mission to realign the Indian judicial system and legal education so that they are closer, in greater sync with the Indian civilizational ethos. Now, why do I say that? I say that because this legal system, which we all know, we've inherited from our colonial masters, the British. The Indian Penal Code itself was framed by none other than Thomas Babington Macaulay, who in 1833 was a member of the First Law Commission of India under the Charter Act of 1833 and 1834. He gave the recommendations, and the IPC, of course, came into force a little later. I think it was in the 1860s, 1862, if I remember right. But remember, Macaulay was the same person who also wrote the infamous Minute on Indian education, right? So this is a colonial inheritance that we have. And yet, the IPC has been amended, if I remember correctly, less chair of that Constitution Framing Committee. I believe that the Indian Constitution has been amended more than 100 times, but the IPC has only been amended 75 times, okay, and also in a very haphazard manner. So the second point I want to make is, yes, eventually we will have to amend the IPC too and Indianize it. But until then, what do we do? Isn't this the biggest challenge in front of us? So what are the steps we can take to realign our judicial and legal system to the Indian civilizational and cultural ethos? It seems to me we should start with a basic realization that in India, there is no word, for law. Just think about it. Don't take my word for it. The word Qanun comes from Arabic. In fact, the entire vocabulary of the Indian legal system as it was practiced during the British period was all from the Perso-Arabic tradition. Because we don't have a word for law. We say Nyaya Laya or Nyaya Dhisha, but Nyaya doesn't mean law. It means justice. So why did we not have a word for law? Because we were, as the previous speaker Umaji said, we were not a legalistic and litigious people, okay? In India, we believed Raghukula Neet Sada Chali Aayi, Prana Jai Par Vachan Na Jai. In other words, a person's spoken word, Vachan, was as good as his or her signed bond. So we were a truth-abiding people who were believers in even oral contracts. Okay, so we did not have a litigious or legalistic system. We were governed by dharma. And dharma, I can submit to you, was an all-pervasive, multi-layered and contextual, as a previous speaker said, system. So it is not dharma as we find in Manusmriti or Yajnavalkya Smriti, because it's actually Manava Dharma Shastra. It was not Manusmriti. In other words, dharma applied to everybody, okay? Even to plants, animals, because it was the innate nature of things. So you can say the dharma of fire is to heat, the dharma of water is to cool, etc. So every item in the universe has an intrinsic dharma. And being aligned to one's dharma, which is swadharma, swabhava. So what I'm trying to say is that this was a society where from the swa, the self, from swadharma to yuga dharma, you had an escalating multi-tier system of self-regulation, okay, and the regulation of everyone else in society, you know. So we had what were our obligations, not just to fellow human beings, but even to animals and plants. So even today, if you do a bhumi pujan or if you do a griha pravesh, you have to apologize for the violence you've done to Mother Earth. You know, the trees that you've uprooted, all the lives that have been lost when you built your home. So now I'm coming to the final point because time is short. How do we go from where we are? So the ultimate objective will be to reform the judicial system, the legal system, which also includes legal education, lock, stock, and barrel, okay, right? Up to the IPC, also the way in which our judges are selected, you know, the bench, etc., etc. We all know we have a pendency of over, if I'm not mistaken, 4.7 crore cases all over India. 4.7 crores, 47 million. Supreme Court alone has a pendency of over 70,000. So obviously something is not working. And I want to remind you, this is the 75th year of India's independence, and we are celebrating Azadi Ka Amrit Mahotsav, but the legal system is almost unavailable to a common individual in India because justice delayed is justice denied, you know. And I remember something that the father of our nation, Mahatma Gandhi, said in Hind Swaraj. You know, the reader asks him, you tell me, I'm quoting Hind Swaraj and Mahatma Gandhi, you tell me that when two men quarrel, they should not go to a law court. This is astonishing. And so the editor, whom people think stands for Gandhiji, replies, whether you call it astonishing or not, it is the truth. And your question introduces us to the lawyers and the doctors. My firm opinion is that the lawyers have enslaved India, have accentuated Hindu-Mohammedan dissensions, and have confirmed English authority. So, of course, Gandhiji was a lawyer, as you know, and so was Muhammad Ali Jinnah, and so is Asaduddin Owaisi. So, if you read Hind Swaraj, Gandhiji says, and he himself, as you know, went to South Africa, he learned about civil disobedience and satyagraha there. He gives us a formula which we can adopt even today, which is from litigation, go to arbitration, from arbitration, go to mediation, and from mediation, go to discussions and have informal ways of seeking justice so that the pendency which is now there in our courts can be reduced, that people can solve their disputes on their own. They can do it if society becomes dharmic. So the purpose of legal education is to spread the idea that we must return to being a dharmic society. Indeed, the governing idea of Hind Swaraj was a self-regulating people who were highly ethical and evolved. Suppose I don't covet my neighbor's property, or I don't want to do anything wrong. In fact, I'm looking out for my fellow human being, for my fellow citizen. Why would I need to go to the law courts, right? And why would anybody feel unsafe? Why would we need a huge police system? We have more than 100,000 police people, police personnel in New Delhi, and yet I can tell you many people don't feel safe. And in fact, all my friends tell me that when a traffic policeman approaches them, they don't like it. They know that either a bribe will be asked or something bad is going to happen to them. They'll say, show me this, show me that. And who has all the things they need, you know? So please understand what I'm saying. But if we become a dharmic society, we will be self-regulating. We will need less policing, less enforcement, less litigation. So to sum up what I've been trying to say, the essence of the Indianization of the Indian legal system as well as Indian legal education consists of trying to inculcate a sense of dharma so that India as a whole moves from law to dharma. And I might as well end with one small reflection for our consideration, that we are very proud and justifiably so of the Indian Constitution. But do you know, friends, that the Indian Constitution does not even contain the word dharma. And this is a society which has more dharma shastras than probably any other society in the world. Thank you so much. Thank you for your time and attention. Thank you, Honorable Chairperson.
Thank you. Thank you.
Thank you so much, sir. Your words were truly enriching and inspiring. Honorable Chair, I would like to inform you that Honorable Mr. Justice Munishwar Bhandari is not able to connect with us.
Okay.
So I would like you to proceed.
I'll proceed. Okay. Thank you.
sir.
Thank you. Good evening, Professor Parajpe, Umaji, Anuji, Dr. Usha Tandon, Dean of the University, Dr. Anju, Ashi, and the other persons present. First of all, Delhi University needs to be congratulated for having taken this initiative. It's a long drawn initiative. And to start with, I can even quote what late K. Hanumantayya said in the Constitution Assembly when he was speaking about the need for framing of the Indian Constitution. He said, and I quote, "We want the music of veena and sitar, but have been given an English band," unquote. So even a member of the Constitution Assembly, when the Constitution was being enacted, formulated in the year 1955-56, thought that the Constitution should be Indianized. And still, we are talking today about Indianization of our legal system. There were many other members of the Constitution Assembly like Pandit Govind Malviya, Loknath Ji Mishra, and Hari Vishnu Kamath, who all wanted certain Indian aspect of the Constitution, Indianization of the Constitution in the manner they wanted. Anyway, be it as it be, we have the Constitution as it is, and now we are talking about Indianization. We started from the Constitution Assembly, and recently the last Chief Justice of India, Justice Ramanna, in one of his major speeches, talked about Indianization of the legal system. And he said that the Indianization has to be in a way that it provides greater access to justice to poor and the needy. And another sitting judge of the Supreme Court, Justice Nazir, had also given a lecture recently where he had talked about Indianization of the legal system. So, as talked by all the speakers, there is no dispute that Indianization of the legal system is required. How to go about it? What is the Indianization we want in the system is a question which has to be deliberated upon, pondered, discussed, and then a decision taken. This forum created today by the university, the time is short, but I would just like to share a few of my experience, which goes to show that yes, Indianization of the legal system is absolutely necessary. When Umaji was speaking, she spoke about various socio-cultural aspects, the approach we have, the difficulties faced by lawyers, the litigant approach to be given. These are all the aspects which have to be taken note of while Indianizing the legal system. Ours is a very vast country. The culture shifts from one place to another. The socio-economic condition shifts, and therefore, while formulating a legal system, all these aspects have to be kept in mind. If you see, go through various reports that are available with regard to reforms of the legal system, you will find there are large number of reports which are lying in the cupboards, which have not been taken out and not implemented. For one, I can give the example of the Justice Malyamat Committee's report for reforms in the criminal law. This report was given way back in the year 2000. 22 years have gone, and even the simplest thing that Justice Malyamat said with regard to amendment of the schedule and making it in the regional languages so that a man in the rural area would know what are his rights under the criminal law, where he should go if he has a grievance, and what is the procedure prescribed. We are unable even to amend the schedule of our criminal procedure code and bring it in tune with the recommendations of the Malyamat Committee. There are thousands of recommendations lying here and there, and we have not looked into it. So therefore, an initiative has to be taken by all of us for bringing into place a legal system which not only addresses the requirement of the entire country, but also addresses the peculiar requirement of the man, last man in the queue. I, as a member administering justice for the last 20 years, have traveled and worked in 3 different states: Madhya Pradesh, Bihar, and Delhi. All the 3 states had different requirement. The socio-economic conditions were different. The requirement of the procedure for dispensation of justice was different. And what I felt was, even in the dispensation of justice and in the administration of justice, there is great disparity. The quality of justice that a man in a remote Adivasi village of Chhattisgarh or Madhya Pradesh gets is totally different from what a man in Delhi gets. The infrastructure facilities are different, the quality of lawyers are different, and even the requirement of the imparting of legal awareness in the litigants are different. You see, when we talk of Indianization of the legal system, we have to take note of the person for whom we are implementing this system. The requirement of a legal system in an urban area would be different from what you have in a rural area or in a tribal area. If you go to the villages of Chhattisgarh, there an Adivasi will commit an offense, he will kill a person, and with the dead body, he will come into the police station and sit there and tell them, I have done this, do what you want to. Now, how do you dispense justice to a man who's sitting before you with the dead body and admits that I have killed him? Just hang him? No, we have to think about so many aspects of the matter and decide as to how to Indianize the law. I have seen, as a executive chairman of the Legal Service Authority in Madhya Pradesh and in Bihar, I have seen that when poor people from the rural areas are convicted, they undergo sentence of 5 to 7 years. And when they go back to the village, the villagers don't accept that. They treat them as a convict who has come from the jail and untouchable, and they are thrown out of the village. Once I was visiting a jail in one of the districts of Madhya Pradesh, and I found 2 poor people sitting, and husband and wife. I asked the jailer why they are sitting. They said, sir, they have completed their 7 years of sentence. They went back to the village. The villagers are not accepting them. So they have come back and they want to go back and spend the rest of the life in jail, because they say, here at least I have shelter, food, and some work to do. That is the system in our country. And therefore, when we talk about Indianization of justice or the legal system, we have to consider how to meet the eventualities of all these persons who are not literate, who don't know what the system is. The other day, I was attending a lecture in memory of Justice J.S. Verma. And the Chief Minister of Madhya Pradesh said that the judgments delivered by the high courts are in English. And when a villager in Madhya Pradesh gets the judgment, he is unable to know as to how the high court has decided his dispute. He is unable to read and understand, and then he spends weeks together in trying to find out what the high court has done with his case, how his dispute has been decided, and he has to get the judgment translated or go to a lawyer or somebody to understand what it is. Today, we don't even have a system of having a judgment in a language known to the litigant. If you have followed the speeches of the ex-president of our country, His Honorable Highness Ramnath Kovind, you would find in every speech, in any court or with the legal system, he used to say, please have your judgments in the regional languages which a litigant of that area can understand. And I found that some high courts have initiated a project for translation of the judgments into the regional languages. So when we talk about Indianization of the legal system, in principle, one thing is final. Yes, Indianization is required. How, to what extent, in what manner is an aspect which has to be talked about, which has to be pondered into. Experts have to sit together and a decision taken. But after taking a decision, the experience in our country has been the decisions are not implemented. You will find thousands of amendments to the law recommended by various law commissions and expert bodies, but nothing is being implemented. I can remember of the Industrial Dispute Act, where the amendment was passed by the parliament way back in the year 1989, but till date, the notification for implementing that amendment has not come into force. So that is how the things are working in our country, and therefore we have to come forward and now take steps for ensuring that even if we want reforms and we have the manner in which the reforms have to come, but to get it implemented. Legal education is a subject which warrants consideration. The legal education, yes, I have to admit that the legal education has changed. The legal education that I had way back in the year 1978-79 is not the one today. When we came out of our college, we did not know what is a courtroom, how is a courtroom, where a judge sits, what he does, where to go. As Madam Uma said, she did not know, she had to depend upon the clerk of a senior to understand many things. But today, with the moot courts, the five-year course, internship in high courts, internship with the Supreme Court judges, internship with the lawyers, a lawyer who comes out knows many things. But what I find these days, and what I found, one very good, interesting thing that Madam Uma said was the pain of the litigant. Yes, pain of the litigant is not felt not only by the lawyers, but even by the judges. As a lawyer, when you talk to a litigant, when he comes to you and you are sitting before him, and when he speaks about his problem, the issue and the consequential effect of that issue on his family members and his economic condition, you feel the pain of that litigant. And when you take up his matter before a court, that pain acts as a catalyst for rendering justice or ensuring that justice is done to that client. But if a lawyer has not interacted with the litigant, the lawyer goes with the file given by the senior and argues in the court, for him, it's only a file. Whenever I talk to judges, I tell them, a case which comes to you is not a file or piece of paper. It's a problem of an individual. That problem has to be sorted out in such a manner that the individual gets justice, because if the individual does not get justice, the society suffers and the society cannot suffer. So therefore, every file that comes to you has a problem of an individual, which ultimately manifests into a problem to the society. And therefore, we have to understand the pain every case that comes to you has and decide it, taking note of that painful thinking. Madam Uma is here. She is an expert on mediation. She is not only one of the best mediators in the country, but she is a mediator trainer also. I have been involved in mediation right from the year 2008. I am neither a mediator nor a trained mediator, but today I can vouch that mediation would be one of the best methods for dealing with the outburst of docket. And as Dr. Paranjpe flagged the issue of pendency of cases, mediation, in my view, is one of the best forum by which the pendency can be tackled, because mediation, as we all know, is a win-win situation for all. It's a decision taken by the parties themselves without being thrust upon them by anybody else. Mediation resolves a dispute from the root level for all times to come. And one experience which I had recently as a chairperson of the Armed Forces Tribunal was I introduced 40 hours mediation to the officers of the army. And now the feedback I get from the army officers are that, sir, it's not mediation or settlement of the dispute, but it has changed our concept of viewing life and dealing with our subordinates in a different manner. Because mediation does not only teach you how to get a matter resolved, but it teaches you how to behave, how to understand a person, how to understand so many things. So mediation, in my view, is one of the best way by which legal reforms can be brought into, and the Bar Council has already taken a decision to include mediation as a curriculum in law courses. And with the proposed bill coming, I feel there would be a lot of change. And therefore, in future, mediation and conciliation should be the forum where the concept of Indian system of mediation and Indian system of resolution of dispute should be introduced. Today, what we follow is more of the Western culture, where people like Madam Uma have created a manual where the Indian system is there. But Indianization has to be there. There are a lot of issues concerning how to reform the legal education system, how to Indianize the legal system. There are various things which we cannot discuss within the 10 days or 10 minutes or 15 minutes that Madam Usha Tandon has given us. I would request her to have a bigger conference or 2 or 3 days where the experts can talk, discuss so many things, give their viewpoint, assimilate everything, and then go back to the government and ask them to work on what the suggestions are made at the initiative of institution like the Delhi University. But one thing I would like to say from what Madam Uma and Dr. Paranjpe said about the approach we should have, the consideration, the brotherhood, the love and affection to the fellow citizen. This is happening because moral values have gone down. We have become more materialistic. We are concerned about hum, me, mera. We are not concerned about others, what others want. So therefore, Indianization of the legal system, reform of the legal system is the need of the day, but it's a huge task. How to go about it, how to bring about it, it's need so much deliberation, so much research, and so much effort to bring it in place. I feel the initiative has been taken by the Delhi University, and it would go a large or it will go to good for the country if we all come out with more positive and thought-provoking way of implementing it. Thank you very much for having given me this opportunity. I have already short the time given to me. Thank you very much. Thank you.
Thank you, Your Lordship. Your words were truly inspiring and enriching. Now, I would like to invite Professor Dr. Rajni Abhi to deliver the vote of thanks.
Thank you, Ashi, for this opportunity. First of all, I would really like to thank all the panelists, not because of what they said, but sparing their time, valuable time for law faculty. Law faculty has definitely taken a very positive initiative, and this has become a very hot topic. 3 days back in a college also, Dr. Subramaniam Swamy had come, and he also talked about Indianization of legal system, and he had his suggestions also. Before thanking everybody, I would definitely suggest to the Dean Faculty of Law that all these suggestions should be compiled as a matter of a report, and they should be sent to not only the Law Ministry, but to the Bar Council also, which frames the curriculum of legal education. Because yesterday in our inaugural session, the Law Minister had come and he was very open to it. And not only open to it, exactly what Justice Rajendra Menon said and you said, that it is the pain of the litigants which should be the foremost thing which we should think about. I mean, instead of going into nitty-gritties and procedural things, it is his pain because he's the one who has come to the court. I think the best way of vote of thanks is to summarize what all of you have said in very few words. Let me just give a summary. We started with Anu, and Anu talked about internalization of, we should first see what we are doing and where we are heading. Then we had come to Uma Ramanathanji. She not only talked about the social milieu, she even talked about what Vidya means and how Vidya is different from education. It is an overall kind of a development of a human being. We should not only talk about information, because we are not computers that some information is fed into us and then at a touch of a button that information has to come out. Otherwise, we would not need judges also. We would have robots sitting in the court where all the judgments are and all the laws are fed and the judgments would come out automatically. So this is very important. Professor Mataran Paranjpe, the best thing which he talked about was a dharmic society. Going back to dharma, the very fact that we don't need courts also, reducing litigation itself. Just to add something to what you said, I think we're talking about definitely 4.7 crore pendency of cases, but almost half of these cases which are pending involve government at some level or the other. If the government itself does its duty at every level, I think half of the pendency of the cases would come to an end. And that would be a great thing. And in fact, when Justice Menon talked about mediation, let me also remind that in ancient times, we did have a system of mediation. Our parents used to mediate, our neighbors used to mediate, the relatives used to mediate, and the problems used to be solved. We never needed to go to the courts of law. And for all this, we have to have a mindset for it. And to have a mindset, I think faculty of law or educational institutions are the best, where we can educate students that they are not the ones to, what you can say, to exploit the victim or the litigant. They should be there to help the litigant somehow. I think if that kind of an approach is taught to the students, it would go a very long way. And talking about Indianization, sometimes I have this dilemma in my mind also. At one point of time, we keep on talking about globalization, and now we're talking about Indianization. We should definitely take points which are good from other societies also, but we should not forget our roots. We should apply them to our roots as we have grown up and as we have learned from our traditional knowledge. Thank you, all of you. It was a very interesting session, and I think every one of us learned a lot. Thank you, all of you. Thank you.
Thank you. Thank you very much.
Thank you, ma'am.
Thank you.
Thank you. Can I take leave?
Thank you.
Yes,
I would
yes.
Okay, thank you,
thank you
Manan sir,
everyone for attending
you.
so
today's
much.
session.
Thank you.
For
Thank you,
chairing the
everyone.
session, sparing your valuable time. I
Thank you,
personally
thank
know
you.
how busy is your schedule.